Good morning. Good morning to those of you on the West Coast. Good afternoon to those on the East Coast, and welcome to everybody in between. My name is Dan Balkaran, and I'm going to be your employment lawyer for the next half an hour or so. I'm going to answer all of your questions that you may have about all things employment law. First, again, my name is Dan Balkaran. I'm an employment lawyer. I'm an associate at the law firm of Samfiru, Tumarkin, Canada's leading employee side employment firm. Okay, so I've been answering your questions I wasn't here last session, so it's been a month since I've seen all of you. It's good to be back. I'm going to, I forgot basic housekeeping matters before I get going. You can reach us if you need to at employmentlawyer.ca. That's the website. You can email us at help@employmentlawyer.ca. You can see it on the bottom there. And you can always call us at 1-855-821-5900 if you want to speak to me or any of our other great lawyers that we have here at the firm. Okay, great. So now that the housekeeping is taken care of, I'll be answering your questions. For the last 6 months or so that I've been doing these sessions, most of the questions have been about vaccine mandates in the workplace. I don't know. They're starting to taper off a little bit, so we'll see how that's going to go. But most of them have been. That issue is starting to die down in the employment bar. Just want to make sure that we're getting all of our questions in here. Okay, while we're waiting for those questions to roll in, we've got one question here through YouTube. We've got a non-union, non-vaccinated, I don't know what LOA means. Human Resources did not accept a religious exemption signed by a priest. You were approved for EI benefits. Can being on EI help get severance or make it more difficult? Is it better to wait until EI benefits are over? So I don't. Generally, if you are laid off or you're terminated due to not being vaccinated, the federal government has said that you are disentitled to EI benefits, and therefore it's an inducement. It's a public policy measure to try to induce people to get vaccinated. So I don't know how you'd be on benefits unless that was independent of your employment vaccination question. So human resources at your company did not accept your religious exemption. I've actually never seen a single religious exemption accepted. I don't really know how that's being hashed out and what the various human rights tribunals are going to decide about that. But it just seems that, and I don't even know, just from a policy perspective, I have no idea how corporations are even qualified to say whether or not a religious exemption is sufficient or not. If you have a note from your priest, I would think that should be enough, but it hasn't been. And I know from my colleagues who work on the other side of the employment bar, who represent employers, some of them just spend or have spent big chunks of days just reading through religious exemptions, deciding whether or not they're valid. And I don't know, I don't remember getting that training in law school. So it's a very strange thing. But, that's neither here nor there for your question. You're approved for EI benefit. Can being on EI help get severance or make it more difficult? So EI, the government taxes your income, and severance is income effectively from the period of termination to the end of the severance period, whatever that is. It's common law severance is calculated pursuant to a formula. Assessed pursuant to a formula. Any EI that you receive, so EI is an emergency fund that you pay into that you can then access in the event that you've been terminated without cause. But any money, any income that you get from another source during that period, the government says, well, you've been sort of double paid, and therefore we want any money that you get concurrent with EI. We want that money back. So, and the government hasn't been forcing people to repay such money during COVID, although it will probably start to do so later this year, I would suspect, or sometime in the new year. So, but whether or not you're on EI doesn't have any bearing on whether or not you're entitled to severance. So just going back to first principles here, your employer can terminate your employment at any time, and your only legal right in the event of your termination is severance. Okay, and it's the amount of your severance that, well, I'm not going to get into the whole spiel, but it's your only legal right that flows from your termination. So if you've been terminated, then you have a right to severance. It's just we don't know how much yet, and we don't know if you're entitled to common law severance, only statutory severance. And for that, you may wish to talk to an employment lawyer. Again, you can always get a hold of us at help@employmentlawyer.ca or 1-855-821-5900. But one is not determinative of the other. They're independent things. It's just that theoretically, if you're getting EI at the same time that your severance is triggered, then, or the same time as when you'd be getting severance, then your EI amount, or the amount of money you got in severance, the amount of money that you got in severance that overlaps with EI, we'll say monetarily, is theoretically repayable to the government. Okay, next question. This is from Rob. My wife's company is being taken over. Can they change her hours? She's been told that she has to work an extra 2.5 hours a week for the same money. So, unless she's exempt from the provisions of her local Employment Standards Act, or her Provincial Employment Standards Act, assuming she's a provincially regulated employee, most of you are, unless she's exempt from that, for every hour she works over 40 hours in a given week, she's entitled to time and a half, or for every hour over 8 hours she works in a given day, she's entitled to time and a half, and then over 12 hours in a given shift, it's double time. However, I mean, so that is the case, but if you, with matters like yours, your wife's, Rob, if you come in with a legal gun and say, well, this is illegal, you need to pay me the correct amount, and which is kind of like a threat to the employer, or if you even take it a step farther and you file an employment standards, I mean, it's different in each jurisdiction. In BC, it's called an employment standards branch, but you file an employment standards complaint for the unpaid overtime, and just be aware of the limitation periods that run in each area. In BC, for example, it's 6 months, so it's a very short limitation period. But if she does that, chances are she's not going to be working there too much longer. I mean, no employer is going to appreciate somebody who's either threatening them or taking them to a legal tribunal for overtime pay. So I think the solution there is going to be something amicable. You chat with the employer, see if they give you a raise, see if they pay her for the extra time, or if it's, before I was a lawyer, I used to run call centers for major technology corporations. I've been through an acquisition before and had to fight for my job, and it's you don't have a lot of leverage with the new company because you have no goodwill built up. You have no goodwill built up at that particular time because they don't know you. And so if you come in, swinging, you come in hot saying, hey, I need this and I demand that, they're just gonna be like, no, you need to get out of here. We'll get someone better. Now, I know, notwithstanding that right now it's a very tight labor market, and so it is very employee friendly because most places are just struggling badly to get employees, particularly skilled employees. But if they're asking her to work 2.5 hours a week for the same money, I think the solution there is amicable. Or it's, if I were in that position, I would probably make sure that they were aware of the fact that I was working this extra time, but I would just work it, do a good job, and then, once I had some goodwill built up, reassess down the road. So, okay. Julia asks, can an employer change your hours if you work in an industry that is reliant on getting new contracts for work? My husband works for a specialized plumbing company and there's less work coming in. Seems to be ebbs and flows with plumbers. I've had this exact same thing happen before with other clients of mine. Can employer change your hours? So, well, I mean, it depends on what's in his employment contract. But if there's no work, there's no work. I, you know, at some point, I'll answer your question a different way. So, at some point, if you're an employee, a reduction in hours and a reduction in pay is a constructive termination of your employment. Okay, so for example, if you're working 40 hours in a week and all of a sudden you get 20 hours in a week, and so your pay is cut in half, that isn't the same contract of employment that you were working under previously, and therefore you can choose to reject that change to your hours, and then effectively trigger your termination and go after severance. Whether you want to do that depends on a whole host of factors, including, and most importantly, what your employment contract says, because it may be that your employment contract limits your severance entitlement to the statutory minimums, in which case you're not going to, it would likely not be in your best interest to trigger your constructive dismissal. But it also depends on other factors, such as how long you've been working for there, how long you anticipate the dip in hours to be, how much you need that job, whether or not there are other jobs you can get relatively quickly. There's a whole host of factors. But I think, Julie, in your case, your husband should probably speak to an employment lawyer. Again, you can get a hold of us at helpandemploymentlawyer.ca and 1-855-821-59. Sorry, yeah, 821-5900. The only other thing I'll say about that, Julia, is if your husband's employment contract contemplates that his hours are contingent upon and commensurate with the amount of inbound work, then it may be that this is not a constructive dismissal. This seems to be a common thing in the plumbing industry, as I was saying earlier, at least from my experience from various clients. However, is it truly a matter of there isn't enough work coming in, or is it that the company is assigning the work that's coming in unfairly to other plumbers? So other plumbers have lots of hours, he doesn't have any hours. And so if that was the case, that would very likely be a constructive dismissal. So again, complicated matter, talk to an employment lawyer. Okay. 1 second. Michelle asks, is it possible to collect EI if you were fired? Okay, so this is a good sort of first principles question. So when you lose your job, and it's not because you quit, okay, you're either terminated without cause or you're terminated with cause. Okay, those are your two options. And without cause has different branches, but for now, to answer this question, I'll just divide into those two buckets. And so without cause simply means that you have an entitlement to severance. Okay, and what that entitlement is, or how much severance you'd be getting, flows from what your legal position is, which is dependent upon your employment contract, and then after that, potentially your age, length of service, and nature of your employment. So that's a without cause termination. So it simply means you are entitled to severance. A with cause termination means that you are not entitled to severance. And that's, there are different ways to get to with cause terminations, to just cause terminations. But classic examples that everyone can be familiar with, you come into work and you're intoxicated, or you're high on drugs, or you steal from your workplace, or you commit fraud, or you punch your boss in the face. Like these are things that can get you fired for just cause. The other way, one of the main other ways you can get to just cause, or your employer can get to just cause, which again means they're legally entitled to pay you zero, is an ongoing series of performance failures or conduct problems that you've been provided clear warning of and an opportunity to correct. So that would be your classic 3 written warnings and you're out. So if you were terminated without cause, you get EI. Okay, but if you were terminated for just cause, the government has said you don't get EI, and that's a government policy. It's enshrined in statute, I believe. And so, if it gets a little more complicated though. So when you said, is it possible to collect EI if you were fired? Well, if you were fired without cause, yes, you get EI. But if you were fired for just cause, then the question becomes, was the just cause legitimate? Now, there are lots of employers, and the reason why employment law exists and why I have a job is there are lots of employers who want to pay zero in all circumstances to employees, departing employees. Okay? And so they will concoct stories in order to justify or claim to justify a just cause termination, which actually isn't one. And the bar for just cause is very high. The law wants you to get severance. It's a bad outcome for you to be thrown for society if you're thrown out in the street with no money and no job. And so the law has evolved this idea of severance over time to cushion your fall, we'll say. So it's a high bar because the law wants you to get severance, but certainly you can meet it depending on what your conduct was. So for you, Michelle, if you were fired for just cause, you don't get EI or severance, but the question then for you becomes, well, was it an actual legitimate just cause termination? And so many of them are not. So I think in your case, Michelle, you may want to talk to an employment lawyer. Again, you can reach us at helpandemploymentlawyer.ca and 1-855-821-5900. Okay, let's move forward. Julian asks, if I'm terminated, I'm legally entitled to severance, right? Then there is a severance entitlement release that removes abilities to sue. Do I have to sign that in order to receive the severance? Okay, this is a great question. So if you're terminated, as I was saying to Michelle, if you're terminated without cause, you're automatically legally entitled to severance. The amount of that severance cannot be lower than the statutory floor if you're provincially regulated, which will be in the Employment Standards Act. It's usually 1 week per year of service. I mean, it's a little different than that, but 1 week per year of service to a maximum of 8 weeks, most jurisdictions. Okay, so you can't get less than that. Okay, and because you can't get less than that, you don't have to sign a release if all they're giving you is the minimum. Okay, but if they're giving you more than the minimum, more than what you're minimally entitled to, if you want that, it's called a gratuitous amount. If you want that gratuitous amount, i.e., over and above the minimum, they're going to make it conditional. The employer is going to make it conditional on you signing a release. And what a release is it's a contractual agreement whereby you and the employer, well, actually, let me rephrase that, whereby you are forever releasing the employer for all future liability arising from your employment. And that's usually going to be comprehensive. It's going to be anything to do with occupational health and safety issues. It's going to be human rights issues, employment standards issues, and severance issues, anything flowing from your employment and termination, everything. So that is what they're buying from you. They're giving you money in exchange for you giving up your rights on a piece of paper to ever come after them again for anything arising from your employment. Okay, so the question to you that you have to answer is, if it's above the minimums, so it's below the minimums, you don't have to sign the release. If it's above the minimums, is you giving up that right worth it to you? Is that money you're getting worth it to you to give up that right to pursue a claim against them in its entirety going forward? Now, I got to remember, as part of that, I bet you that release has some sort of confidentiality and non-disclosure clause, which means you can never talk about your settlement and really anything negative about your former employer ever again to people. So you've got to weigh all that out, and whether or not you should sign it depends on your legal position. I sound like a broken record today, but you probably should talk to an employment lawyer just to see that you're getting a fair deal. Again, you can get a hold of us at helpandemploymentlawyer.ca and 1-855-821-5900, as you can see on the screen right now. Okay, Derek asks, I have a strange question. If an employer is banning unvaccinated workers because the landlord they lease the land from has a policy in place to require anyone on the property to be vaccinated, is it a legal policy? Can the landlords leasing out a property put in a policy to the people leasing the land? Okay, so this is a really interesting question, actually. So I'm going to assume you work in a building. Okay, the building, it doesn't actually matter. You work. Let's just say you work in an office. Okay, you work in an office, and your employer doesn't have a vaccination policy, mandatory vaccination policy, but the building they rent from implements a mandatory policy that all of its tenants have to be vaccinated, and so that forces you to be vaccinated. So if if your employer doesn't comply with that policy, then it could be evicted, which could potentially be fatal to its business. And so the question is if you refuse to get vaccinated, is your employment frustrated because I honestly, I don't know the answer to that question. I'd have to put some serious thought into that. I don't know. Because I could see it both ways. So what frustration is the idea that through the actions of a third party or some sort of third party event, all the obligations under your contract of employment are dissolved. Okay, so a couple classic examples: you work in a factory burns down, you can no longer go to work. It's not the employer's fault. It's not your fault. Employer doesn't have to pay you anymore, and the employer doesn't have to pay you severance because there's no possibility of you being able to work. Although there have been some decisions that talk about if the factory is going to be rebuilt fairly quickly, then it does. But you get the idea. It arises mostly in the context of people's serious health conditions. So someone has a really serious health issue, they can't work for 2 to 3 years. There's no possibility of them returning to work in a timely manner. Then at that point, the employer is relieved of all obligations of severance. Okay, so that's what frustration is. It's basically your right to severance, at least for your purposes. The right to your severance is extinguished entirely. And so if you refuse to get vaccinated and the landlord has implemented a policy, is your right to severance extinguished because the employer didn't necessarily have that policy, but it's being dictated to, and it could lose its lease. I don't have the answer. Derek, if you want to contact me offline, you can send me an email. You can reach me at employmentlawyer.ca. Just look me up, and I'll see if I can sort that question out for you, because in some ways I could see it being frustration, but in others, well, okay, so the tenant, it's not the tenant's policy, and if you violate it, does it, by not being vaccinated, and it gets evicted, it can still carry on its business. It just has to move. So that's a very interesting question, and I'll have to, if you want to contact me directly, you can just find my email address on the website, send me an email. I'll see if I can sort that out for you. Question from Rick: does an employer have to pay out severance if they let you go before the end of a 15-month contract position? So it's a great question, Rick. So it sounds to me like you're on a fixed term contract. If you're on a true fixed term contract, like you are employed for 15 months. At the end of the 15 months, you don't have a job unless the parties agree or that the contract is renewed, which could be in the terms of the contract. If they let you go at 12 months, they owe you for the remaining 3 months. Okay, unless there's a termination provision in your employment contract which permits them to terminate your contract early while still complying with if you're provincially regulated, with the employment standards acts and regulations that are in your jurisdiction. So, for example, if you're a 15-month employee, they let you go at month 12 and 1 day in British Columbia, that means you'd be entitled to two weeks notice, 2 weeks pay in lieu of notice in that situation. But if there's a valid termination clause that says that, but if there isn't one, then they'd owe you effectively just a day shy of 3 months. Okay, so Rick, you may want to kick the tires on this with an employment lawyer. I know I keep saying this to everyone, but it's very difficult for me to give you proper advice with just sort of a short blurb. There you go, employmentlawyer.ca. You can reach us at help@employmentlawyer.ca and 1-855-821-5900. I hope I answered your question, Rick, but it's going to depend on if there's a termination clause in your employment contract. If you didn't sign an employment contract, but all the parties agree that you're on a fixed term contract position, then I guess it would be for the remainder of the period of the contract. Now, if you have a 15-month contract and they fire you after month 1, then you could have 14 months coming to you. You definitely want to talk to an employment lawyer in that situation. However, if they got rid of you at 14 months and 2 weeks, it's not probably worth it to talk to us. So you've got to do that assessment, or it's probably not worth talking to a lawyer because your best day is 2 weeks anyway in that situation. So do the assessment. But I hope that answered your question. Derek's back. Can landlords dictate a vaccine policy to the land they leased out? My employer says a vaccine policy is in place because the landlord has a policy and to have only vaccinated people on the property. Okay, that's okay. Thanks for that added context, Derek. So it doesn't matter what your employer said in that situation as to its motive. Its motive doesn't matter. Well, I mean, it will matter in terms of the assessment of fairness. But in this case, your employer implemented a vaccine policy, and if you don't follow it, I assume you're going to be fired or put on unpaid leave. Now, theoretically, as there was no vaccine policy that you'd agreed to in your contract of employment, your employer can't just simply impose one upon you and then fire you without paying you severance for not being vaccinated. Now, there have been a few, so you should be entitled to severance. However, there have been a few arbitration decisions out of Ontario recently. So arbitration is it's different. It's not a court of law, but the adjudicators are senior lawyers generally. And I think these have been mostly in a union context, but they've upheld these arbitration decisions have upheld the imposition, we'll say, of mandatory vaccine policies by the employer. Most of those cases, I think, had to do with retirement homes. So the question of the extreme vulnerability of the residents, I think, makes that different from most people. But a few of these decisions weren't, and they've upheld the employer's right to impose a vaccine policy. Well, not just impose a vaccine policy, but fire you without paying you severance for not following it. I don't see how at law that can be valid or will withstand, I guess, legal scrutiny through the judicial process. You don't have, like, your employer can't just add new terms to a contract without a contract of employment without fresh consideration, and then hold you liable for the terms that it just imposed upon you, particularly when that term is injecting something in your body that you don't want to have injected into you. And the arguments in those arbitration decisions have been, well, it's in the interest of the herd, we'll say, of all of the employees, for health and safety. But it's a strange thing that an employer can say, we're going to fire you if you don't follow what we say is your medical best practice. I just don't see how that could possibly be legal yet, other than it's a public policy decision. So it's an arbitrator in that case deciding what's in the best interest of society. And I don't know if a judge is going to go that way or not, but it's an open question right now to answer your question. Derek, I'll just say, theoretically, you have a severance case against your employer just because your employer says it did it because its landlord imposed this policy upon it. Doesn't necessarily relieve your employer of responsibility, but it's a very hard one, and you certainly are going to want to talk to an employment lawyer. Again, helpemploymentlawyer.ca, 1-855-821-5900. Okay, JC. JC is a frequent visitor of this space. Good to see you again, JC. Buddy of mine works in a foundry, and his hours were cut a while back. They did something called work share. Sure, government pays part of his wages. I think the government paid part of it. I don't know if that would be available for the plumber. Okay, so yeah, but I mean, the employer has to decide. Like, there's no positive obligation to engage in work share. The employer has to decide if it wants to do that. So, and I don't know very much about work share. There may be various riders upon it that the government attaches. So, question from someone with a unique name, so I won't say it. Can you help someone get their position back if they've been put on leave due to vaccine mandates? I mean, the short answer is probably not. Okay, so I think that's an amicable solution, or you're going to have to reach an amicable solution with your employer. Listen, whenever you hire a lawyer and the lawyer, gets involved and starts sending letters to anybody, if it's an employer or if it's a divorce case to your wife or husband, like it never gets less acrimonious at that point. I mean, sure, there are situations where I have, where a lawyer can write a letter, and it can, the fear of the legal consequences or financial consequences could get you back in your job. But it's vastly more likely that what will happen is your employer will be just really upset at you than you involved a lawyer, and there's no chance of you ever going back. So I think, labor market's tight. People are having a problem with it. If you call them back and say, hey, I loved working here, I want to continue to work here, you have this vaccine policy, I can't be vaccinated for X, Y, and Z reasons. Is there any way we can, have me do rapid testing? I'll pay for the rapid testing, or can I work from home? Or is there some combination we can meet? Maybe you can work something out, but yeah, I don't think that I can get you back in, or that a lawyer could. Derek asks, I think it's the same guy about the landlord. Okay, yeah, no, I've already answered that question, Derek. JC is back again. If you sign a contract that specifies an amount for severance limitation and years later you are let go, but at that time the money amount is less than the legal minimum, is it grandfather? You can never get paid less than the legal minimum on termination. Okay, so if the termination clause purports to give you less than the legal minimums, it's in every jurisdiction. I think it's I know in every jurisdiction, if it purports to give you less than legal minimum, that termination clause is invalid. So you would have a good severance claim, I would think, there. So you're going to want to talk to an employment lawyer again. help@employmentlawyer.ca, 1-855-821-5900. We are very much out of time, but we've only got a few questions left. So I'm just going to, if the moderator will bear with me, I'm just going to see if I can power through these. Can a government agency fire you if you've received all medical, if you've gotten all medical information that you can't wear a facial mask for your entire customer service shift? We live in strange times where it doesn't matter what your individual medical practitioner, your doctors say. Medical notes, governments have come out and said, well, it doesn't matter what your doctor says. You can only have exemptions for X, Y, and Z reasons. Very, very strange. The foundation of modern medicine as it meets law is that the relationship between doctor and patient is such. Well, medicine is individual, right? So no one knows more about your health than your doctor, and the idea that you can cookie cutter medicine is just sort of anathema to, I'll say, personal injury law. But here, I think you're asking the wrong question. If can they fire you? Yeah, of course they can fire you. They can fire you for whatever they want. The question is, whatever reason they want, is, are you entitled to severance? And culturally, the cultural tail wags the legal dog, or maybe it's the other way around. I don't think there's going to be a lot of sympathy for you within within legal spaces, in front of the court for not wearing a mask, unless you've got a really compelling, like, asthma reason. But even if it's a psychological reason, and I know I've talked to people who have, claustrophobia issues and things like that, I don't see there being a lot of sympathy there. So maybe can you work out some sort of compromise? Again, I sound like a broken record. I keep saying the same thing over and over again. If you can work out a compromise, that's best. Like, you wear a mask for 2 hours, you don't wear one for 2 hours, you structure your breaks accordingly, you work from home on certain shifts. Like, I don't know, but it's not a situation where, like, you're going to get fired if you just tell them no, hard no, I'm not wearing this, right? So you have to assess whether or not I shouldn't say you're going to get fired, but the odds are increased that you're going to. So you want to assess that. You want to assess how much you need the job. If it's a government job, you've got a nice pension coming to you, most likely. So there's a lot of things to weigh. And again, you can reach us you might want to talk to an employment lawyer, help@employmentlawyer.ca, 1-855-821-5900. Last two, same guy, physician stated employee could wear a face shield and the agency denied it. Okay, that's a little different, much more sympathetic there. Like, you can wear a face shield, but you can't wear a mask, and you've got medical reasons. It's a tough one, but again, you're staring termination right in the face, and you've got to you've got to decide what the balance is. But it also could be that medically there's just no way you can wear a mask, in which case the chips are going to fall where they fall. So I would definitely talk to an employment lawyer. And you've got potentially very serious consequences to your employment, though, if you don't, and it's just a matter of severance that flows from it. But it depends on your situation. It might be that the job is more important than some severance, especially if you've got a nice pension coming to you. JC again, I don't. If a landlord can put in a vaccination policy, that might be a property law. Okay, so JC is giving legal advice. Thank you, JC. Okay, those are all the questions. Those were great. Good to see familiar faces again, like JC. I'm glad you're participating. Thanks. Come back when I'm here in 2 weeks. I will be here 2 weeks from now. You're right, JC. The property question is very complicated, or the landlord question is very complicated. That's why Derek can email me if he wants. Join us on Monday, May 2nd with Chris Justice. He will be laying down the law with respect to all your employment law questions on Monday. I will be back in 2 weeks. I don't know the date exactly, but I'll be back in 2 weeks in this space. I'm every Friday, 10:30 Pacific, or every second Friday, 10:30 Pacific time. Great questions. I'm glad we could get through all of them today. You guys have a wonderful weekend, and I'll see you in 2 weeks. Thank you.